unmute the mics, and anything you say in the courtroom for the Attend the court, please. The Honorable Supreme Court of the State of New Mexico. Please be seated. Good morning.
This is S-1-SC-39169, Sipp versus Buffalo Thunder Incorporated. Can I have entries of appearance, please?
Timothy White for respondent, Sage Rader, Caroline Sipp. Excuse me. Mrs. Sipp. Excuse me.
Daniel Raygar on behalf of petitioner and respondent, petitioner and defendants.
Mr. Raybear, it appears that you have designated 22 minutes for your argument in chief and 8 minutes for rebuttal. Is that correct?
Yes, Your Honor.
All right. Thank you. You can take it away.
May it please the court. There are two independent reasons why this court must reverse the Court of Appeals. First, under the Supremacy Clause, Bay Mills' binding, narrow interpretation of gaming activity throughout the Indian Gaming Regulatory Act, or IGRA, limits this court's decision in Doe regarding jurisdiction shifting under Section 8A of the Standard Form New Mexico Indian Gaming Compact to claims that are directly related to and necessary for licensing and regulating playing Class 3 games. Second, even without that, jurisdiction shifting under Section 8A ended per its own termination clause based on final federal court decisions in Nash and then Dally, and now also Chicken Ranch and Pueblo Pewaukee versus Wilson, regardless of irrelevant exceptions in Nash and Dally.
So Mr. Raybear, I want to take you to the termination clause. I'm particularly interested in it. It seems to me that both parties here have conceded that a final determination means a determination from a court, not an appellate court, not a court of last resort. So I'm curious from your perspective, using contract interpretation, because the compact is a contract, how you interpret that language in the termination clause.
I interpret it such that it has been triggered by Nash and Dally, and since then by Chicken Ranch and Wilson. But
tell me why. Why is that language consistent with your opinion? I mean, I've debated this in my mind for days. In appellate parlance, a final determination is a decision by an appellate court. And so I'm focusing on Nash specifically for this because Nash is not an appellate court. It was Leroy Hansen. In the compact itself, it uses that term, a final determination by a court.
yes,
So I can argue, that I can argue it both ways. A final determination means an appellate court, either Court of Appeals or Supreme Court in either system. Or I can argue that it is a court, meaning any court, but taking that to its logical extension, it could be a magistrate court. A state magistrate court judge could look at this and say, I don't think this flies. And is that a final determination for purposes of the compact?
I don't know in which circumstances a magistrate court would be addressing this issue.
Use a federal magistrate court.
Well, a federal magistrate judge would be only acting for an Article 3 federal judge issuing a decision. Final has a very specific civil procedure rule, a civil procedure meaning.
Mm-hmm.
Final means all appeals have been exhausted or all the time periods for an appeal have been exhausted. So there can be no dispute that these are all four final federal court decisions.
Go ahead. If you don't mind. So I can follow that to a certain degree, but take the Nash opinion. The Nash opinion is a district court decision.
Indeed, as
In an our system, a state court decision, district court decision, is not, assuming all appeals have been exhausted, is not binding on anyone except the parties in front of that judge. It does not have greater import than the parties in front of it. Using Nash as the example, Leroy Hansen's decision in Nash bound the parties in front of him, if I use that rule of civil procedure type of definition, and wouldn't be binding on anybody else.
It is not binding on anyone else, but for the fact that the state of New Mexico and all of the tribes who signed this compact agreed to that specific provision in their compact.
And what would we do if we found the language to be ambiguous in the termination clause?
If it is ambiguous, then it should be interpreted as the parties would have understood it, or if anything, in favor of protecting the Pueblo's jurisdiction and sovereign immunity.
And what's your support for that?
The support for that, I believe, is Doe and Mendoza, which did address those issues in terms of ambiguity in the contract. It was not ruled on.
Well, no, what case law suggests that we have to interpret it in the tribe's favor?
In terms of
If there's an
waivers of sovereign immunity and changes of jurisdiction for the Pueblo, they have to be interpreted in favor of the Pueblo. But I don't even think that you need to go that far.
Mr. Rabier, I want to add to the chief's hypothetical. Let's assume you have a district court judge saying that the IGRA prohibits waiver of jurisdiction. And another district judge, say in Oklahoma, says it allows it. Which one is applicable? And then let's say in the middle of those, you have a Pueblo judge ruling one way or the other.
The key word is or. The parties agreed to language that says a final state or federal court decision. Certainly this court in Doe and Mendoza versus Tamaya Enterprises has ruled that jurisdiction shifting is allowable under IGRA.
and it predates Nash, Dowie, et cetera, correct?
Yes. Mendoza versus Tamaya Enterprises does not. But again, the parties agreed to this language and it says or. And as this court said in Doe, the parties must be bound by their contract language.
So that's in section 8 of the compact.
8A.
Okay, but let me take you through section 8. Section 8A says that the safety and protection of visitors to a gaming facility is a priority of the tribe, and there's a purpose here to protect those who suffer bodily injury. And it continues. 8A ends stating that unless it is finally determined by state or federal court that IRGA does not permit the shifting of jurisdiction. Subsection B then says there's a requirement for insurance. Okay? Then subsection C provides a statute of limitations. Subsection D then says it's a specific waiver. The tribe, by entering into this compact and agreeing to the provisions of this section, waives its defense of sovereign immunity in connection with any claim for compensatory damages for bodily injury or property damage up to the amount of $50 million per occurrence asserted as provided in this section. This limited waiver does not waive the tribe's immunity for suit for any other purpose. And that they'll ensure again, and it says that the tribe shall ensure that a policy of insurance that it acquires to fulfill the requirements of this section shall include a provision under which the insurer agrees not to assert the defense of sovereign immunity on behalf of the insured up to the limits set forth in the paragraph. Further, the tribe agrees that any claim brought under this section New Mexico law shall govern the substantive rights of the claimant and shall be applied as applicable by the forum in which the claim is heard, except that the tribal court may but shall not be required to apply New Mexico to a claim brought by a member of the tribe. And then it says a visitor having a claim described in this section, this is in subsection E, says that the claim may be pursued in any court of competent jurisdiction. So there seems to be an inconsistency between A, section 8A, and subsection 8D.
Your Honor, the language that you quote relates to two particular preliminary points that I think are very important to keep in mind. First, under Williams versus Lee, the default jurisdiction here is only at the Pueblo unless IGRA expressly allows otherwise. This court acknowledged that in paragraph 18 of Doe, as well as paragraph 14 of Mendoza versus Zleta Resort, quoting Daly. It's also implicitly recognized in paragraph 8, or in the termination clause of section 8A. Second, this case is not about whether there is a remedy. As the court just referenced, compact sections 8AD through 8F, at record proper pages 49 to 50, specifically waive tribal sovereign immunity and provide for the visitors to have the option of pursuing claims in court or in arbitration. Likewise, as we have noted, the Pueblo in its tribal code, as the state has done through the New Mexico Tort Claims Act, has waived its sovereign immunity for claims in tribal court. Plaintiffs here had the option of pursuing arbitration. They had the option of going to tribal court. They happened to choose to go in state court after Nash had been decided that triggered the termination clause. In addition,
the termination clause is only triggered if it's determined that IGRA does not permit the shifting of jurisdiction.
Indeed.
And let me just read you the decision from Pueblo Santa Ana versus Nash. Conclusion. The court hereby enters a declaration that IGRA does not authorize allocation of jurisdiction. So there's a difference, it seems to me, in a conclusion that it says it doesn't authorize it versus it prohibits it. Tell me what I'm missing.
I think that you're parsing the language, and if you look at plaintiff's brief in chief below at page 8 of their brief in chief, as well as paragraphs 11, 12, 13, and 15 of the Court of Appeals decision below, they both recognize that Daly and Nash squarely addressed this issue under the termination clause. Whether, as the Court of Appeals said, the question addressed by Daly and Nash was whether IGRA permits an Indian tribe to allocate jurisdiction over a tort claim arising on Indian land to a state court.
Permitting it versus prohibiting it is two different things in my mind.
Well, except the protection of visitors language is IGRA does not permit. And so you're saying the Court of Appeals acknowledged that they were focusing on whether it was permitted or not.
The issue that is in the termination clause. Indeed, both the decisions in Daly and Nash, as well as the subsequent decision in Pueblo-Milwaukee versus Wilson, confirm that termination clause has been triggered. And when the Court of Appeals said, well, those are narrow decisions, the only thing that's narrow about what possibly remains. So when if court references claims like those brought by the McNeils, it's not a wet bathroom floor, so that if the claim about a dry bathroom floor is still allowed. Pueblo-Milwaukee Wilson makes this clear. It was a claim about someone mere steps away from the slot machine walking to the ATM. And the court there, in another final decision, which again triggered that clause, ruled that Daly isn't limited to the bathroom. Even if you're someone proximate to the slot machine, if you're not actually engaged in gaming, IGRA doesn't allow it. And if it doesn't allow someone mere steps away from the slot machine, it doesn't cover someone at the back of the hotel at a loading dock.
So let me probe that with you a little bit. So Nash uses the language, IGRA does not authorize an allocation of jurisdiction from trial court to state court over a personal injury claim arising from negligent serving of alcohol. That's a quote from the conclusion. Daly also narrows it, but narrows it in a different way to my mind, and it's in a footnote.
7.
Yeah. And in that footnote, their narrowing of their decision is consistent with Bay Mills, which is that, the oft quoted, rolling
Roll
the
of the
dice.
Yes.
And they say, we're not talking about that, but we're talking about tort claims that are unrelated to the act of gaming. Is that a fair way to read Nash and Daly and their attempt to narrow their opinions? Is that fair? And I'm going to ask Mr. White the
yes,
same
that is fair.
question.
I mean, essentially, opposing counsel and the Court of Appeals would have you believe that in order to trigger the termination clause, there would have to be a decision that said, in no way, ever, in any circumstance, by the highest court of the land, can there be any possible jurisdiction shifting. Leaving irrelevant, final doesn't mean without irrelevant exceptions. Final means final. But I think the most important point is to bring it back to Bay Mills, as you noted.
I have a question, Mr. Raber, before we go there. So does that mean that Section 8A of the Gaming Compact allows for case-by-case determinations? Some tort claims, IGRA may not permit jurisdiction shifting, but some tort claims it may, and that's what the parties contemplated when they accepted and executed Section 8A of the Gaming Compact?
For purposes of jurisdiction shifting, to the extent it is allowable, it is entirely appropriate that the courts recognize that if it's not allowable in that situation, it's not allowable.
And then my follow-up question is, wouldn't the natural reading question then, if that's what the parties intended, of Section 8A to be they were going to litigate those disputes out in state or federal court and not let a state judge in Montana, for example, with other parties on a dispute that they're not even involved in, make that determination? Isn't that a fair, if that's the case, that this is case by case, some tort claims yes, some tort claims no, isn't it a fair reading that really these folks said, well, then we're just going to litigate about those things later?
Yes.
But they're not here. The state's not here.
The state has not entered into any of these cases to assert that this is not a correct reading of IGRA or the compact. They're not here today.
All right.
That brings us to the first reason why the Court of Appeal should be reversed. Under the Supremacy Clause, Bay Mills' narrow interpretation of gaming activity in IGRA Section 2710 D3C1 necessarily, substantially, and preclusively limits this court's decision in Doe regarding the jurisdiction shifting under Clause 2 of that section.
Can't Bay Mills be limited though? Because Bay Mills was talking about gaming activity not on tribal land. Seems to be an important distinction in Bay Mills.
Absolutely not. This
Why?
case is directly controlled by the Federal Supremacy Clause and under James versus City of Boise, cited by Plebble Amici, as well as this court's decisions in Schedule and Harrison. This court is bound by U.S. Supreme Court decisions interpreting federal law.
But here,
The
the context of that interpretation was off reservation
A
activity.
statute cannot have one interpretation for one of language and have a completely different interpretation for another purpose.
Oh, I think it absolutely can, depending on what the statutory history is.
The United States Supreme Court in Bay Mills specifically interpreted the language gaming, Class 3 gaming activity in Section 2710 D3C1, which Clause 2 depends on for jurisdiction shifting. The Supreme Court ruled gaming activity there means the roll of the dice, the pull of the slot machine. Under Harrison in particular, for matters of inter-country jurisdiction, this court is bound by that interpretation of IGRA. That ruling necessarily limits tribal casino tort claim jurisdiction shifting to matters that are directly related to, quoting the statute, plain language, and necessary for licensing and regulation of actually playing Class 3 games.
Do we have to reach that question here? Can we write an opinion that doesn't involve Bay Mills, doesn't involve overturning Doe, but says that Section 8 of the compact has been triggered, the termination clause has been triggered by Nash, Dowley, et cetera? Can we write a more narrow opinion that goes that direction without touching Doe and addressing Bay Mills?
You could, but in order for plaintiffs to win, they must win both on that issue and on asserting that Bay Mills doesn't mean what it says. I direct your attention in particular to Black's Law Dictionary, as this court just referenced in its most recent published decision in Ray Victor Marshall 1. Black's Law Dictionary defines gaming and gambling to mean the act of risking something of value, especially money, for a chance to win a prize. That cannot include parking lot light delivery, the loading dock at the back of a hotel. And Bay Mills made clear that gaming activity has one set meaning in its plain terms throughout the statute. And under Hobbs, this court's decision in Hobbs, it cannot have one narrow meaning in 11 separate sections, but a different meaning for different purposes. Moreover, Doe substantially relied on legislative history, 14 paragraphs over 4 pages. But Hobbs and Moongate preclude that extensive resort and reading of tea leaves in legislative history when the text is clear and unambiguous, as Bay Mills said. Under schedule.
In Doe, didn't the court both say that it was ambiguous and not ambiguous in the context of the majority opinion?
It was, yes, based on the legislative history.
So they both said it was very clear and ambiguous at the same time.
Under schedule, this court must overrule prior decisions that are inconsistent with intervening federal decisions. Based on the Supremacy Clause in Bay Mills, as well as based on the Termination Clause and 4 final federal court decisions, the Court of Appeals decision must be reversed.
Thank you. Mr. White.
May it please the court, Mr. Raybear. Your Honors, we understand that the federal cases that the petitioners cite have taken the position that their application of the plain meaning rule compels a conclusion that IGRA precludes the tribe from consenting to state court jurisdiction under the compact. But using that procedural approach, those cases have ignored the overwhelming evidence that we were just discussing of the congressional intent behind IGRA that culminated in the question being presented here being the exact point that Justice V. Hill raised a little while ago, which is the question here is, does IGRA prohibit this in shifting of jurisdiction?
Can I just ask you, because we ended on this issue and it started at the beginning and it's really what's hanging on my head is Section 8A of the compact. Take the other issues aside. I mean, if you go to the provision at issue, unless it is finally determined by a singular, not plural, a state or federal court, it doesn't say appellate court, it doesn't say court of final resort, it says just court, that IGRA does not permit the shifting of jurisdiction. How do you guys get out of that contract provision? I'm not seeing that as an issue where we prevail in this case. So convince me that I'm wrong.
Because finally determined in New Mexico law means this has been determined by a court of final jurisdiction, as the question was posed earlier to Mr. Raybear.
And isn't that the 10th Circuit?
We're looking at.
And isn't that the 10th Circuit? It doesn't say a final determination by a state court. It says a final determination by a federal court. And the 10th Circuit satisfies that.
Except that's not a final determination
If
of this question, Your Honor, because the 10th Circuit didn't address this question.
I
They
I
flipped the question.
wholeheartedly disagree with you.
The 10th Circuit flipped this question around from does IGRA permit this? Are the 7 mentions of things that can be interpreted, negotiated into the compact that are in IGRA, is that an exclusive list or are those examples? Because the language says may be. The language of IGRA says these matters may be included. And one of those matters is how state law and jurisdiction applies to the regulation and licensing of these gaming activities. Really, because we don't get to a final determination by either of these cases. If final determination meant a decision by a district court, a state district court, a federal district court, then we're going to reverse precedent of this court in Doe on the basis of a final decision by a state judge
This isn't
somewhere.
about the rules of civil procedure or even the law. This is about what the parties, the state and the tribes contracted to do. So we have to focus on contract law,
I agree.
not the rules of civil procedure, not what you and I would normally think a final determination is. The parties contracted to a final determination by a state or federal court. It didn't limit it to an appellate court. It didn't limit it to a decision by SCOTUS. It didn't limit it to an opinion by this court. The party said, we're going to rock and roll along under this unless and until a state or federal court says IGRA doesn't permit this shifting. So Doe to me is irrelevant here because the parties kept rocking and rolling. This court said, in a divided opinion, Doe said, okay, we're going to say, yes, there's jurisdiction, but that doesn't trump the contractual agreement between the parties. To me, Doe can stand as an opinion that existed in its time. But now, multiple courts have said IGRA does not permit the shifting of jurisdiction. And so we're in a new day. The termination clause is triggered based on the contractual agreement of the parties. And here we are.
Your Honor, I would submit that these 2 federal court decisions cannot have finally determined the question that's presented here of whether IGRA does not permit shifting of jurisdiction.
What about Bay Mills?
Bay Mills was interpreting a completely different issue. It's a different question. Bay Mills was being asked whether or not the tribe had waived their sovereign immunity.
What about the definition in Bay Mills that's been used in these other 4 cases subsequently to address the very issue in the compact?
Because they're defining gaming activity. But the compact says that the sovereign immunity is waived if a New Mexican is injured, a customer, a visitor to the gaming enterprise was injured by the gaming enterprise. Gaming enterprise is much broader than rolling dice or pulling the lever on a slot machine. Gaming enterprise was what brought my client to the premises in the first place. And so when we're looking at the definition that Bay Mills gave to gaming activity, we need to look at that from 2 perspectives. One, this compact applies to much broader than just gaming activity. It applies to injury caused by the conduct of the gaming enterprise. Two, gaming activity in this compact has to logically apply to anything within the gaming enterprise. And so
That's not
you
what
can,
IGRA says. You're adding, you're taking, we're prior to section 8A, which is what the parties agreed to. I agree, this is contractual. I don't think we need to. Still has to determine, it's about IGRA, and IGRA doesn't refer to gaming enterprise. IGRA refers to the gaming activity, and that was what was agreed to by the parties. So that's true that section 8A of the compact refers to gaming enterprise, but in this last provision where we're looking at the IGRA, that's what I want you to focus on, because how do we get out of that? And I don't think it's by the language of the contract saying that there's broader terms. How do we get out of saying this provision doesn't prohibit jurisdiction in state courts?
because Bay Mills wasn't interpreting this question, Your Honor. Bay Mills was interpreting the question of whether the tribe had waived its sovereign immunity from suit by operating a casino off of tribal lands. Michigan was trying to say that's gaming activity when you are operating your casino off tribal lands from your tribal lands, okay? It's a completely different question. They were saying gaming activity was going on by virtue of managing from the tribal land, and therefore the tribe had waived their sovereign immunity because they're engaging in gaming activity. But the Supreme Court said gaming activity isn't managing your casino from another location off tribal lands. Gaming activity is rolling the dice and so on. But that's not the question here. The question here is, does IGRA prohibit this?
So let me quote Pueblo Powaki versus Wilson to you. The Indian Gaming Regulatory Act does not permit the allocation of jurisdiction by Indian tribes to the states over tort claims that arise from circumstances which are merely in proximity to Class 3 gaming activities, but not actually involved in the playing of the game.
Following down the Daly case.
Yeah, but it's still a final determination by a court saying, nope, doesn't permit it. And that's what the parties contracted to in the compact. They said, we're going to set aside appellate law. We're going to set aside what we know to be normal litigation reality. And there were a bazillion lawyers at that table, I promise you, because I was part of it. And this is what they agreed to. It's a contractual provision. They can contract to do all kinds of stuff. And Congress said, you guys can go contract to whatever craziness you want to, but then you're bound by the contract.
It's still, Your Honor, not a final determination when it's a case from a court that does not, under the rule of stare decisis, under New Mexico's
That's
approach
not
to...
what the contract says. I would agree with you all day long, Mr. White. I really would. If the contract said a final determination by an appellate court, a final determination by a court of last resort. That's not what the parties said, for better or for worse. They said a final determination, meaning no further appeal is, the time for all appeals has run by a state or a federal court, regardless of rank within that hierarchy.
Your Honor, to interpret the party's intent in that aspect of the contract, to say that any decision from any state or federal court would be a final determination that would then relieve the petitioners of their obligations under this section of the contract would be to believe that the painstaking negotiations that you were a part of they were entering into a contract that that was gonna be unenforceable the minute some magistrate judge
So wait,
decided
But,
that
but
IGRA
that's
doesn't
what,
permit.
that's frankly what they did. And if your position is that this is ambiguous in some way, boy, does Blackfeet kick you in the teeth. Because Blackfeet unambiguously says if there is an ambiguity, we at great pains interpret it in favor of the tribe because that's sovereign immunity. And that's frankly the penalty for all Indian tribes and the way that they have been treated historically is that's why we have this, concept of, dependent, independent nations. Blackfeet very squarely says, if there's any ambiguity, guess who wins? The tribe. And that was the point of Justice Minsner's dissent in Doe.
The issue though there, Your Honor, is that, yes, as a general rule, you weigh these questions in favor of protecting the tribe's sovereign immunity. But Kiowa Tribe and CNL Enterprises both say, unless the tribe waives their immunity, which both those cases found there was a waiver based without any basis in congressional statute or permission or the affirmative authorization that the petitioners seek here,
But if
that
they
is
wanted
not
to
in IGRA.
wholeheartedly waive in the compact, they could have. Instead, if they wanted to completely waive and not have any question about this jurisdiction of IGRA, they could have done that. That's not what they did here. Let me ask you this. I can try to understand it from your perspective. At what point, because I know we have at least 2 United States District Court cases. We have Bay Mills, we have a 10th Circuit case. If that's not finally determined, what in your mind is? When would finally determined happen under this?
Finally determined in terms of triggering this clause, Your Honor, would be a decision by this court or the United States Supreme Court, because those are the only
Why
jurisdictions.
didn't the parties say that? Why on earth did the parties not say that? They drafted this contract. They could have eliminated, frankly, the last sentence in A and avoided all of this mishigas, all of it. But they didn't. They put this in and they didn't say a determination by a court of last resort. Not even close. So using contract interpretation principles, I don't see how we get to your point. I tried to get there. I really did. I just don't see how you get there.
I think you get there, Your Honor, by looking at that and saying, okay, perhaps at least, Mr. White, that's an ambiguous term. Then you have to look at the entirety of the enterprise, the contract. What was the purpose of it? The purpose of this section is for the protection of visitors to the casino.
By
section
going
makes-
down Mr. Raybear's path, we're not eliminating the safety and protection of visitors. There are 2 other paths for protection. So I've heard this so many times from myriad lawyers, not just you, like, well, state court is better than tribal court. I mean, it's that paternalistic view of our sovereign courts that, well, if you can't go to state court, there's no remedy. Well, that's patently false, because here the state has waived its sovereign immunity to go into tribal court. Tribal court has jurisdiction here. I know you also would also argue that arbitration is a lesser cousin than state court, but it's very paternalistic to take the position that state court and tribal court are not on equal footing for purposes of protection.
We haven't made that argument.
But that's what it smacks of when we say there's no protection if we enforce this clause as some of us may want to interpret it.
what protection remains if this termination clause has been triggered for even the person who is walking away from the slot machine because they need to use the restroom,
The
or
trip
is
and-
walking away to get the ATM so they continue to gamble. To read this so narrowly would leave any of those persons who are engaged in the gaming activity that petitioners want to narrow this to protect. Nobody else is going to be protected from that. And that's a completely illogical
That's not true. You
result.
can go to tribal court.
I'm sorry.
You can go to tribal court and duke it out.
Yeah, this is.
This doesn't eliminate the ability to go to tribal court.
And under these provisions, if they go to tribal court, state law is going to apply. So there's certainly a level of protection there. It sounds like the argument is it's not as satisfying.
Which is that paternalistic point I was trying to make.
Which is not what we're saying at all. I want to be very clear.
Okay, and I understand you don't intend that, but that's the logical consequence, is saying, well, if it's not state court, there's no protection. Well, no, tribal court is a logical, viable avenue. Arbitration is too, but I'm not going to fight with you about whether arbitration or a judge are better. Would be against my own best interest to do that. But you can go to tribal court and bring these claims. There's nothing that precludes that when we're interpreting subsection A of the compact.
Mr. White, do you get any help? Does your client get any help from the concept that is in footnote 7 of the Daly opinion, which is to the effect of, that court at least was saying, I'm not going to go so far as to say there can never be a tort claim arising from gaming activity that would not be allowed to be brought in state court under the IGRA. Does that give your client any help with respect to the meaning of this gaming compact provision in section 8A? Because it specifically reads that a state or federal court, that the IGRA does not permit the shifting of jurisdiction over visitors, all visitors, personal injury suits to state court.
I think that it could, Your Honor, but I don't think that Judge Holmes in the 10th Circuit, who wrote the Daly opinion, would agree with that, because
I don't think you would either. That's why it's in a footnote.
because,
I agree with
you know, in my opinion, and I don't mean to be impertinent, but hiding that little bit in the footnote was an attempt to perhaps soften the blow of the real holding of that case, which is you don't have a claim in state court ever unless you're rolling the dice or the blackjack dealer hits you with his cards or, you know, something. You're actively involved in gambling. And
So you agree that that's Daly's holding? I just want to figure out where we have agreement. It's your position is it's not a final determination for purposes of the termination clause.
both of those ideas are correct, yes.
Okay, I appreciate that, just so that I can
Yes.
start to filter through what the debate is.
And really, to go back to the final determination issue, Your Honor, it just, to me, seems a completely illogical reading of the contract language. For us to say that any state court, any federal court could issue something that would be a final determination of whether the statute does not permit shifting jurisdiction. There's
But
no way that a
riddle
lower
me
court
this.
could make a final determination on that question.
The parties were kind of in this time frame, you know, as IGRA comes out, you know, you got IGRA, the early days of IGRA, Congress takes it away, IGRA comes back, Congress approves it, and then everyone is off to the races. And literally, off to the races. People are working as fast and furiously as they can to get Class 3 gaming up and running in a state like New Mexico. And their IGRA doesn't clearly say, Congress didn't say, you shall waive your immunity because it would violate sovereign immunity. They said, but the parties can negotiate this. So they're in this context of the unknown at the time they're drafting the compacts. They're saying, okay, we'll agree that there's jurisdiction in state court for personal injury cases right now, but that may change. And we've got to know that that may change. And then we've got to draft this compact in such a way that if that changes, the rest of the compact survives. That's what the last sentence of Section 8A does for me, is it says we're going to agree that this is the landscape until some judge, and they don't define what kind of judge, but some judge says this doesn't work. And then the termination clause kicks in, but it allows the rest of the compact to survive because otherwise every single casino in the state of New Mexico would be thrown into massive upheaval because there wouldn't be a compact anymore. I mean, that's reality of what was happening real time when the compacts were negotiated. So if that's the backdrop, then the termination clause makes sense.
Well, maybe not. Because what about competing court opinions?
I'm sorry, Your Honor.
What about competing court opinions? What happens there? Does this termination clause mean that you've got 10 opinions that say IGRA doesn't prohibit it? Then you get one court somewhere saying it does and there's no appeal. Does that trump all the others?
And that's why a reading of the contract language to say that any decision by any state or federal court anywhere would be completely illogical, because that's what
the
we have
parties
here.
contracted to. They said, we're not worried about competing opinions because, Doe comes along, Supreme Court says, we're okay with this. But the trigger hasn't happened. But the parties contracted to, once one court says it's not available, all bets are off. I mean, that's what Section 8, giving its plain reading, dictates. It doesn't say
and that's why,
a final determination by a court of last resort. That's not what the parties contracted to.
except you can't read that as what the parties contracted for without reaching the illogical result.
I don't think it's that illogical
That-
because IGRA hadn't been interpreted yet. It's by a court. The language that's at issue in Doe, Bay Mills, that language hadn't been interpreted yet. So it made perfect sense to me that the tribes would want to preserve the possibility that they could retain jurisdiction under IGRA by entering into this contract when it had not yet been interpreted. So I guess I'm not seeing it as illogical, especially in light of the circumstances when you're just given a statute that no court interpretation of it has yet occurred. And especially knowing that really it's an exception to the rule that a tribe would give up its jurisdiction. It really is a narrow exception to.
And as I thought about that aspect of the language that we're talking about, the termination clause, it occurred to me, if they wanted it to be anything else, it would have been real simple to say, or a court, a state or federal court, determines that it does. One decision anywhere, if it goes this way, that's the way it is. If it goes that way, it is. But I noted they didn't do that either. And so they just put the termination clause in the way it's written. And I think that says it's not illogical for them to have agreed that if this decision comes down anywhere.
Where does that leave us then, Your Honor, though, in the instance that Justice V. Hill cites, where we have 20 cases saying IGRA does permit this for this claim, for this tort claim. And we have one case from West Virginia, no disrespect intended, but how could these parties, a New Mexico tribe and the state of New Mexico, have entered into a contract by which they meant in this language that, okay, we're going to throw this out if a West Virginia district judge decides IGRA does
Congress
permit this.
told the parties they could contract to what they wanted to.
But you can't read it that way.
Oh,
Yeah.
there's a very plain reading here.
It is,
There-
but
there
it's
is.
the plain meaning rule, and this is where the federal courts went off. Justice Montgomery told us in State versus Smith that we need to approach interpreting a statute.
This is not a statute, it's a contract. Very, very, very different rules. I agree.
We're
with
talking
you
about the
100%.
plain meaning rule, though.
No, but the plain meaning rule in contract is totally different than it is in statutory construction. So I know what you're gonna quote to me, because gets quoted to us all the time.
Okay.
That doesn't have any application in the contract world. The contract world is really different than statutory analysis. And so the plain meaning rule in contract world is much easier for the appellant here.
But we look at the entirety of the contract, Your Honor.
Mhm.
And the entirety of the contract says, the priority of the state and the tribe is to provide protection for these visitors.
Huh?
And we agree
has no-
to shift jurisdiction. I'm working on the contract here, so.
Yeah,
We agree to shift jurisdiction unless it's finally determined by a state or federal court. Again, I just don't understand how in New Mexico jurisprudence, we are going to interpret a contract that uses that language, which is at best ambiguous, or at least ambiguous, excuse me, what to mean that we're going to be bound in the interpretation of a federal statute in New Mexico by virtue of the decision of any court anywhere in the country. That, to
We don't have
me,
to
we don't
decide
I don't
anything.
see
we
how
can
the
just say
parties-
Dowley does it, and it's a 10th Circuit case.
I'm sorry?
We can just say Dowley does it, and it's a 10th Circuit case. It's not a far reach for New Mexico then to say, well, the 10th Circuit has interpreted federal law. Here we are.
But Dowley, again, based its reading on the interpretation of the statute. And they were interpreting a different section of the statute that had to do with sovereign immunity, not shifting jurisdiction. Dowley,
Sovereign immunity and shifting of jurisdiction are inextricably intertwined. You don't get to shift jurisdiction without waiver of sovereign immunity. There would be no argument here if the tribes hadn't said we're going to make this limited waiver under a limited circumstance. I don't see how you divorce those.
I'm about to be out of
I
time,
understand.
Your Honor. I just want to conclude by saying what the petitioners really are asking this court to do is reverse Doe. Really make no mistake about that. If you read their brief, that is their point. They want to be relieved of this obligation that they agreed to in exchange for making millions of dollars in the state and enjoying that benefit. They want to be relieved now of this obligation
I
to
understand that.
go to court anywhere other than tribal court or to arbitration. That's not what they agreed to. And this court in Doe said that. Thank you.
May I ask one question, Chief Justice?
Of course.
Do you have any information about whether and why the state of New Mexico has not joined in this dispute in this case?
I do not.
Okay, thank you, Mr. White, I appreciate that.
And I was going to ask you to comment on Justice Menzner and Judge Sutton in Doe when they both pointed out that it wasn't an agreement at all. It was an agreement to disagree. And that when you correctly interpret the may be brought, it should correctly be interpreted as may only be.
If it was interpreted as may only be, I would submit that it would say may only be, and the statute does not. With respect to the other question, again, if you are to look at the contract language and say, we're not agreeing to this, we're only agreeing to litigate it later, then you end up with an illogical result. Why would the parties agree to something that's contrary to the plain language of the statute and extraordinarily contrary to the legislative history that's pointed out in multiple paragraphs in Dow. Why would they agree to contractual language that just says, we're just going to kick this down the road? That's not a contract. That's not an agreement. Instead, they agreed that they were going to do this unless there was a state or federal court that finally determined this question about whether IGRA does not permit this. And again, how can that apply to the decision of some inferior court anywhere in the country when we're talking about a contract entered into in New Mexico by New Mexicans, by the tribes here, and by the state of New Mexico? It would be a completely illogical reading of the agreement, Your Honor.
All right, thank you.
Can I ask one? I just, I'm probably beating a dead horse, but I guess I take a little offense to saying that it would be illogical, because they're agreeing to one of the most fundamental principles to any tribe, the Navajo Nation, any Pueblo, which is their sovereign immunity. So to me, it doesn't seem as illogical or irrational in any way to limit the possibility that they may not need to waive it as much as they have. And so I guess, I don't know if you want to respond to that. I take a little offense to the fact that it's illogical, because at the heart of our sovereign nations is their sovereignty.
Your Honor, I don't have any other answer for that other than what we've already explored.
Thank you.
Mr. Raybear. Thank you, Mr. White.
Thank you.
I'd like to start with paragraph 15 of Doe. Supreme Court there said, we will not ignore the clear language of the compact, nor can we relieve the parties of the compact of their obligations. The parties were well represented by attorneys when they negotiated the compact. They purposely punted on this issue, and it's entirely appropriate that they did so. And as the court has noted, they could have used different language, but they didn't. They specifically used the language that they did. And while opposing counsel references this could be any court anywhere, and that would be illogical, we don't have that situation. We have two decisions by the Federal District Court in New Mexico and the 10th Circuit. Daly was not about a different section of IGRA, and it was not about tribal sovereign immunity. It was about jurisdiction shifting, the precise issue here.
So, Mr. Raybear, you quote from Doe versus Santa Clara, paragraph 15. Paragraph 13 says, that they quote the, Justice quotes the compact. The language of the Pueblos agreed to in the compact gave state courts jurisdiction over personal injury claims conditioned not upon IGRA allowing jurisdiction shifting, but upon IGRA not prohibiting jurisdiction shifting. And the paragraph ends, nothing in the language of IGRA prohibits jurisdictional shifting. Paragraph 16, the court repeats, as we have seen, there is nothing in IGRA that does not permit the Pueblos and the state to do exactly what they agreed to do here. And the language you quote from paragraph 15 is to bind the Pueblos, was the result in that case. My question is, does the Supreme Court opinion, the final word under state law, carry no weight under Section 8A and Section 8D?
It certainly carries weight in terms of the final decision that the court made at that time. But as Justice,
but it was the compacts were then renewed. Did the parties not have a right to rely on Doe when they agreed to renew the compacts?
The parties continued that language in the new compact.
I understand.
They
but-
could have deleted it and said, Doe has settled it, we're done. But they didn't. They kept that language.
So Doe means nothing.
Doe meant what it stood for the time that it was effective in terms of
When
under
did-
the compact, the parties agreed to this language.
Okay, so when did Doe cease becoming effective?
In
Cease to
terms,
be
in
effective.
terms of jurisdiction shifting, in 2013, once Nash became final, before the alleged accident occurred. In 2008, in case that wasn't enough, in 2018, when Daly became final. And in case that wasn't enough, last year, when Pueblo-Pewaukee versus Wilson became final.
So those cases had the effect, if I understand, of overruling that one singular sentence from paragraph 13 of Doe, that this Supreme Court said nothing in the language of IGRA prohibits jurisdiction shift.
Those
When we're talking
decisions,
about competing,
those decisions couldn't say anything about Doe in terms of affecting Doe's precedential value. It's simply a matter of applying the compact language in the termination clause as the parties drafted it. What's important to keep in mind, however, is that under Bay Mills and this court's decisions in Hobbs and Moongate and Schedule, this court is bound by the U.S. Supreme Court decision regarding the interpretation of IGRA. There is no way around that. If there's any more authority, I cite to you Padilla versus State Farm, 2003, New Mexico Supreme Court 11, paragraph 7. This court doesn't hesitate to overrule even recent precedent when law has developed to leave the old rule a remnant of an abandoned doctrine. We're not asking you to overrule Doe. We are simply asking you to accord with the U.S. Supreme Court's decision as required by the U.S. Constitution.
But again, we can write an opinion where you win that doesn't even go there. It's
Absolutely.
just based on the contract.
Absolutely. I'd also note that opposing counsel referenced in their argument C&L Enterprises. That was a case regarding off-reservation tribal sovereign immunity as a purely contractual matter, and there was no federal statute involved. Here we have a specific federal statute that specifically limits the matters that can be addressed in compacts. And under this U.S. Supreme Court interpretation of the statute and numerous federal court decisions, it is limited. In sum, the supremacy clause itself, as well as James versus City of Boise, as well as this court's decision in Hobbs, Harrison, and Moongate, refute the assertion that Bay Mills is not dispositive and only seemingly contrary, as the Court of Appeals said. Under Hobbs and Moongate, Bay Mills' plain language interpretation of IGRA precludes consideration of any other asserted matters, whether it's a preference for state court or otherwise. Are there any other questions?
I do have a question, and if it's in the briefing and I missed it, I apologize to everyone. I don't know, how often is the standard gaming compact renegotiated? Is that a part of the contractual provision of the gaming compact itself? Do you know? And if you don't, that's fine. It's not.
The compacts have set terms. The compact that was in effect at this time was signed in 2005. There's a new one from 2015.
When will that expire? When will it come up for renewal? Do you know, Mr. Raybear? I do not.
I do not have
Okay.
the expiration date offhand, but I know that since the parties, as I understand, have not been intensely negotiating, there's still some time left.
Okay. Thank you. That's very helpful. Thank you.
Okay.
In conclusion, the Court of Appeals decision has to be reversed, again, both under the supremacy clause per Bay Mills and this court's own rulings regarding canons of statutory interpretation, as well as independently under the termination clause as triggered by 4 relevant federal court decisions.
Chief Justice, I do have one more question. I apologize. If it's okay.
Yeah, very quickly.
Quickly, Blackfeet talks about a construction from statutes. That's my understanding. Is there a similar case, you know, of Mr. Raybear that talks about giving tribal sovereignty a preference when it talks about contract interpretation?
There are rulings regarding interpretation of contracts relevant to waivers of tribal sovereign immunity that say, it requires, the Supreme Court has a clear statement.
Same
rule.
principle?
Yes.
Okay, all right, thank you. Thank you, Chief Justice.
Of course. Gentlemen, thank you for your presentations here today and for enduring robust questioning.
Yes.
And the case is deemed submitted as of today, and we'll get back to you when we can. Thank you.
Let's
Thank
have
you.
the court, please.
Wait.